Hello? I think there was a momentary glitch whereby everyone was logged out, if I'm not mistaken.
Yeah.
Yes.
I'm so sorry. I'm just getting everyone who was there as part of that group to get back into the... Yeah, so sorry, continuing. So that's what I'm saying, that 18 to fourth proviso to 18 correlates to 1910. That's what the Supreme Court said when it was deciding the 2016 judgment. So our argument is, if at all that there is a need for this particular right to be exercised, it is to be limited to those situations either where there is an independent album being produced only in relation to sound recording aspect and not being part of a film, or if there is really a situation where there is, for whatever reason, there is neither an engagement in terms of B nor an engagement in terms of C, the provisos B and C to 17, and in which case there will have to be an assignment to transfer ownership, where then these provisos will kick in. So anyway, so I'm saying that this is still something which has to be adjudicated upon by the courts, and which way this goes. Any questions?
So again, just a thought again. In case of a exploitation of sound recording, even if IPRS asserts that their rights are not defeated, can I say that your rights are only limited to claiming of royalties? And since I'm paying to PPL, your claim rests with PPL and not with me. I have taken a license to exploit a sound recording which comprises of your underlying works also. If you say that exploitation of sound recording also amounts to exploitation of the underlying works, what you're essentially saying is I am also entitled to some kind of commercial benefit out of it. And if it is so, whatever license fee I am paying to PPL, IPRS claims lies as against PPL for taking a share of it, and not to me, because I don't have to take two separate licenses from two separate entities for exploitation of one class of work.
Yeah, so I understand. So essentially, you would say that if I understand your question correctly, your point is that even assuming that this right of royalty was to be implicated and relevant for the purposes of these exploitations, then the user of that work should not be the one who should be required to pay that royalty. It should be the one from whom the license has been taken. So let's assume in the scenario, let's say the producer of a film, it's the underlying work author, and it is, let's say, a television broadcaster or a radio broadcaster. In that event, neither of the broadcasters will pay to IPRS, or as the case may be, whoever it is that is concerned. But it is the producer who will have to pay, because we are paying allegedly the producer, and then let the producer then figure out how to distribute that. And you may not be incorrect in that, and that's one of the arguendo arguments, that assuming without conceding that such a such a situation of right of royalty does exist, if you read that proviso, it says, provided also that the author of the literary or musical work included in a cinematograph film shall not assign or waive the right to receive royalty to be shared on an equal basis with the assignee of copyright.
Correct.
So who is the assignee of copyright? Is it the question is left hanging by this? Is it the first assignee of copyright?
Yeah.
Or is it every subsequent assignee or licensee?
That's the biggest confusion in both these sections, 18 and 19, with whom who is liable to pay whom and who is liable to share with whom.
Correct, absolutely. And that's one of the arguments that we are raising, that the practical workability of a provision also has to be looked at when you are considering whether or not to uphold someone's rights who's seeking that. And therefore you have to look at a situation where it the presumption is that it is workable, and it will be workable best if you limit the interpretation of the word assignee to the first assignee. Yes. That's the entity from whom, where, and whom all the rights are flowing downstream.
So as I mentioned yesterday about the scenario of a production agreement, this again becomes a point of contention between the production house and the platform owner. Right. Because the production house says that because we are the face with the authors and we are taking the first assignment, we become the assignee.
Right.
And the platform says that because we have commissioned work, you are just paying on my behalf. You don't become the assignee, I become the assignee.
I understand that, and that's how it's likely to raise a greater amount of problem unless this clarity came.
Correct.
Abhishek, I have one question. We talked about the proviso of section 17 and its multiple interpretations. Now, on a practical level, because this is not being challenged as of now, right? You and me could have a different interpretation of what 17b entails, the proviso not. So currently, when I'm doing a work for hire model, which is 17b, I am essentially doing work for hire plus taking an assignment, for all the underlying, aspects of the work, because I would be creating a program or a film, say for a particular film and a program, and whatever else is there, if I need to adapt, I would have the right of adaptation by virtue of the assignment. Is that the current model which is being followed as an industry practice, or do you think it's the current model which needs to be followed till there's a clarity?
I'm so sorry. I didn't understand the question. Sorry.
Okay, so I'll come back with the question. Under 17b, there's a proviso which is then added, right? Which essentially says that nothing shall affect the rights of the order.
Proviso is at the end. I mean, it's not immediately.
Yeah, not to 17b per se, but the proviso, the 217 section, right?
Yeah.
Now, before 17b and earlier, live before the amendment was that I would do a work for hire model where I need a program, say, or a film to be created, and everything else by virtue of that work for hire model comes back to me, including the underlying works and the literary works, etc. Now, because of that, interpretation issues of the proviso, that whether it's only the rights, the economic rights vest with the author, or even, their underlying works remains with them, except for a purpose for which they've assigned. So the question that I have is that when I'm doing a work for hire model and say I'm asking a production house to create something for me and the authors to, create a script or whatever, do I just go under the work for hire model 17b and I don't need a specific assignment for the underlying works? Or pending the clarity of the proviso as to what does it entail and what does it minus, is it the workable solution to have a work for hire as an overarching clause and then an assignment for the separate literary and underlying works that we have?
No, so my suggestion, okay, first of all, because the legal position is not very clear,
right?
We're looking at it from a practical advice standpoint,
right?
The manner in which your clause should be framed is your default position is that it is a work made for hire,
right?
Or a commissioning work under B,
right?
So when you are looking at it as a commissioning work, you are then necessarily putting in language to construe the movement of the rights in relation to the underlying works directly to you immediately upon creation, right? And in which case everything is owned by you. The
Right.
interpretation that I am according to the last proviso to 17
Yeah.
is that it is no different from 13.4.
Okay.
And 13.4 has been interpreted by the Supreme Court to say that, look, yes, the independent existence of that work is not in question.
Right.
There is a work that exists independent of the film or the sound recording, as the case may be.
Correct.
We are not challenging that. All
Right.
that we are saying is, if you were to give it the meaning that IPRS or the underlying author composers wish to give, which is that every time that a film is exploited or a sound recording is exploited, every time that is done, there is a requirement to pay the underlying owner or underlying author. The effect of that would be to defeat the composite whole work, that the rights that have been given under 14D and 14E. And 17 new proviso does not do anything to alter that position. If at all, as Prashant was mentioning, if at all, what it preserves is the commercial right under 18 provisos. But to my mind, even if it does, first of all, it does not preserve that right, because once everything is granted under B as a commission work, nothing remains to be granted by virtue of an assignment. And the only place that you find the commercial right of receiving royalty comes in is in relation to an assignment. So if you're not required to go down that path to come to the assignment situation, then 17 proviso does not do anything different, is my interpretation. But again, coming to the commercial reality, you would draft your clause in such a manner so as to say that A, I'm construing this to be a commission work under B, and therefore I'm the owner of everything.
Right.
You will also recognize that the other party is seeking to, to highlight the requirement that there is a right of receiving royalty, but in your mind, that right of royalty does not exist till such time that this particular aspect is not clarified. You create a subsequent clause saying that in the event that it is the position of law, or it is decided by the apex court by virtue of final order, that there is nevertheless a right of royalty despite this being a commissioned work. In such case, X, Y, and Z would follow.
Okay.
So you have a default position of B, and you create a commercial protection for yourself to say that in the event that there is this clarity that is brought about by the Supreme Court, and you categorically say final court of a competent jurisdiction by final order, that clarity is brought in that case, the royalty, if any, shall be payable by X or by Y, and it shall not exceed such and such amount. Because if you notice, even assuming that you are to give effect to these royalty provisions,
right,
and to presume that they are actually valid and enforceable against you, one challenge that you will face is that it is enforceable against an assignee. So question number one is whether you are the assignee. The second issue is it says to share equally. Now, how do you decide what is the pie that needs to be shared equally?
Correct. Yeah, that's been the moot question. Yeah, that's
absolutely.
Right.
So because of these unworkabilities of these challenges is how you will then may have to by contract agree on a modality of sharing of royalty of a particular amount.
Yeah, I got
it. As a via medium.
So essentially what you're saying is the only, in your point of view, the only issue is about whether royalty is to be paid, whether it's a commissioned work, is royalty still be payable to the authors or not. But in terms of rights being assigned to me, which includes all the underlying works, there is no question around that. That continues to be same, right?
Absolutely.
Okay. Okay. Thank you so much.
Most welcome. Any further questions? And again, happy to respond even offline by virtue of emails or otherwise if you guys have any thoughts or any questions around this. But if there are none, then thank you so much for participating once again in this session today. We hope that either we've managed to confuse you enough or tried to make some certain points clearer.
Yeah, it was certainly helpful.
We're going to continue the series of our sessions even tomorrow and day after, and we will shortly circulate an email with regard to topics. There were a couple of topics that our colleagues had been working on, so we just take a final call on that and circulate that. And if it is of interest, then you're most welcome to participate.
Abhishek,
The links will remain the same. Just FYI. Yeah, please.
Abhishek,
yes.
This is Kripa here.
Sure.
From Viacom 18. So just an extension of what Shriti's asked you. By putting an assignment clause in the agreement, we're basically acknowledging the existence of author's royalties to be payable to the author. So it's in our interest not to include the assignment clause in the agreement, right?
I agree with you, Kripa. If you can manage to, I'll tell you what the trade-off is. Ideally, you should only limit it to an engagement by virtue of commissioning, and that's how the interpretation that at least today I'm affording or I'm pushing. If it does get the acceptance of court, then we're all home and dry. Now, in the event, however, that you don't insert an optional clause that, assuming without conceding that it is held by a court of law by way of a final order that such a royalty is payable, then we will deal with that in such and such situation. So all that you're doing by creating a secondary optional clause on assignment, you're not seeking an assignment in that case. All that you're saying is that it will be construed as one. The engagement that you are undertaking will be construed as one. And in the event that there is a requirement to pay royalty, it shall be dealt with in the following manner. So you are effectively, by virtue of a commercial understanding here and now, trying to foreclose a possible litigation or dispute to be raised by the underlying author, who could then take you to court and say, look, I was all along saying that this is payable. They were not agreeable. They took a stand that this is only a commissioned work and therefore it does not need to be paid to me. But now Supreme Court has held that it is a requirement of an assignment, and if it is to be construed as one, then I need to get payment as per my right of royalties. So it's only to obviate that lack of clarity that you're only trying to protect yourself commercially. However, if someone wishes to take a stand and a hard stand at that this is what we are taking and we'll see what happens in future, then so be it. It's a commercial decision that one has to take.
Okay. But wouldn't it still be safer for us to have that assignment clause at the risk of an author's royalty being payable as opposed to us being questioned on the assignment of rights per se from the very beginning?
I agree with you. So therefore, the suggestion from my side, from a commercial standpoint, should be or is that please have a default position that this operates as a work made for hire or commission work. But have that assuming without conceding situation there, that in the event that the law changes tomorrow, as per what your understanding is, and there is a payability of royalty, then this is how you will deal with it.
Which is to substantiate that while I'm agreeing to pay authors royalties, there is an inherent understanding that you've also agreed to assign those rights to me. Right? So as to establish, so let's say for example, for now you're saying that there is no requirement of any assignment to be given because there is no assignment left, right? But
Correct.
Tomorrow, if that were to be challenged, the only thing that we would be protecting ourselves right now is to accept the fact that there is an author's royalties to be payable, which I would anyway have to pay later on, right?
Correct.
So by including this clarification, I'm establishing an existing or a retrospective assignment, so to speak, to say that while we also acknowledge that we were ready to pay authors royalties to you if that is the case at a later stage, the understanding was also for you to assign those rights to me. So basically I'm securing my rights assignment also along with that clarification.
I agree with, so that's what I'm saying. So you are the language of your clause would read in such a manner so as to construe the engagement of a commissioned on a commissioned basis. That will be the engagement on a commission basis shall be construed as an assignment of copyright.
Got it.
Right.
Okay. Okay. All right. Thank you so much.
Sure. All right. Thank you all. Thank you so much.
Cool. Thanks, Abhishek. Thanks, Sapna.
Thank you.
Thank you.
Thanks.